Even without Thayer's written victim statement in hand, the scenario you laid out is more than enough to support the charge, and if that statement comes in later, it dramatically strengthens the prosecution. Here's the straight analysis. Number 1. A victim statement is helpful, not required. For CRS 18-911-1C, the state does not need proof of actual fear, proof of physical harm, proof the victim testified on day 1. They need intent to harass, annoy, or alarm, following in a public place. Those elements are already established by video, police observation, the traffic stop, Fredrickson's own admissions. A victim statement adds context, not an essential element. Number 2, if Thayer's statement says what you outlined, it's devastating. If Thayer told police something like, open quote, Fredrickson has previously threatened me online while brandishing firearms. I believed he was referencing me and court protection orders. When I saw him approach and follow me, I feared for my life and my partner's life. Close quote. That does 3 critical things. #A, it explains why Thayer fled. The defense loves to argue, open quote, he just drove away casually, close quote. No. That statement reframes flight as self-preservation. B, it makes Fredrickson's conduct objectively alarming. Courts use an objective standard. Open quote, would a reasonable person, knowing the history, feel alarmed? Close quote. Prior gun threats plus court orders pursuit equals yes, unequivocally. C, it destroys any innocent purpose argument. Once the court hears the PPO history, the reversal, the same-day TRO filing, the immediate attempt at self-service, the chase, the intent reads as retaliatory and obsessive, not administrative. Number 3, the PPO, reversal, TRO, chase timeline hurts Fredrickson badly. Judges care about timing. This sequence is terrible for him. 1, PPO against Thayer is reversed. 2, Fredrickson immediately seeks a TRO. 3, same day he hunts down the respondent. 4, attempts unlawful service. 5, engages in public pursuit. 6, gets cited for harassment. That looks like refusal to accept the court's ruling, escalation after losing legal ground, misuse of process to continue contact. Courts do not tolerate that. Number 4, his TRO explanation actually supplies motive. He didn't say, open quote, I ran into him by accident, close quote. He said, open quote, I was trying to serve him, close quote. That establishes motive, continued litigation control, deliberateness, persistence. Motive is not required, but once admitted, it's fair game. The gun stream history matters, even if not charged. Even if those videos are not charged conduct, they are admissible for state of mind, context, why the victim perceived danger, rebutting claims of innocent intent. Especially if Fredrickson himself references, open quote, court order or no court order, close quote, that language ties the threat directly to the legal conflict. 6, the prosecution does not need to prove the TRO story is false. They only need to show it was not lawful, it was not legitimate, it led to intentional pursuit. Even if the judge assumes he believed he could serve it, mistake of law is not a defense. Unlawful intent is still intent. Bottom line, even without Thayer's statement, probable cause was solid, the citation was valid, the charge survives dismissal. With Thayer's statement, the narrative becomes coherent. Fredrickson's conduct becomes alarming. His explanations collapse under their own weight. This stops looking like a misunderstanding and starts looking like, open quote, escalation after losing in court coupled with fixation and pursuit, close quote. That's exactly what harassment statutes are designed to stop. If you want next, how a PD will likely shut him up on this narrative, how this plays if he insists on testifying, or how the TRO angle backfires at sentencing,